It's changed. Like where I used to work. But in my found that. I find that.
Yeah.
These are like.
And you're like, oh God, like,
So close, but I don't, somehow I have.
Because.
But.
Yeah, I used to wear contacts, and I gave myself corneal ulcer restrictions.
Oh my God.
And the doctor said, oh, you're lucky, that wasn't like in the center of your vision.
Yeah.
So don't wear contacts anymore. All right. Hey,
she sold.
without you.
Yeah.
Why are you grateful?
Our printer will not print that beautifully.
Hey, Maria. Hey, Etta.
So the old ladies.
Hi there.
Yeah.
You know what we left off?
We left off at paragraph 34 is where we're gonna start.
Yeah. It's a good thing. Good thing to do for your phone and things like that. You know, it's like, we're in a black hole.
You're gonna have to go. She called me up.
Yeah, that's right, yeah. It's really good. I like it. I mean, this is really nice.
So, or have something else before actually.
That is so cool. I can't wait to get them out. I mean, 20 neighbors to you and 4 clients. You want your neighbors? Yeah.
Good job.
Pop by for
Mark's little farmhouse down the road, she had it upstairs in your.
I like it.
I want to make sure everything's okay.
So in the scratch off, everyone's a winner. When they call, but hey, you want lunch with me? What do you mean?
That's really cool.
So.
I like the coin too.
Yeah. Major scratch. Well, I think I have.
That she falls in the phone.
phone and G.
Bring your arm, their arm already.
And you can always take time out and.
All right, Mark, you got the floor, you ready to go?
I'm ready.
I'm up then. I'm up.
I have no idea what we're talking about, but I'm ready. Well, we got a few people online. I'm mislabeled as Joe Buffington, but
Yeah.
I think people know better.
Sure, I got like two. I did not.
All right, guys, let's get started. Hello and welcome, everybody. Thank you for being here. I'm Mark.
Yeah, Mark.
So we're going to talk about contract and maybe we'll get to some addenda. We left off after paragraph 33 last time. So we're on section 5 of general disclosures. And we've gotten to the portion of the contract where there's sort of a bunch of miscellaneous stuff here, and then we get some important stuff again. So we'll speed up and slow down and stop me and ask questions if you need to, if I choose a place to speed up and you think we should slow down. So here we go. 34, pretty straightforward. Buyers advise that they have the right to get a disclosure or disclaimer statement. Unless, of course, it's exempt because it's a sale, you know, from an estate or something like that. So you guys remember there's a handful of exemptions that not required. What is interesting is if it is a trust, like seller puts their property in a trust, there is on the exemption list, you know, a trustee selling is exempt, but that refers to like a court-appointed trustee rather than I put my property in trust so I don't have to make a disclosure or disclaimer statement, right? So a little different there. You got to delve into that. Ground rent, thankfully, we don't see a lot of it around here. There's a little bit, but not a tremendous amount. If there is ground rent, there's a procedure. There's procedure for buying out the ground rent, which I recommend because just be done with it. It's usually not very expensive, a couple $1,000s, if that, to buy out ground rents. So there's a whole procedure for that. Lead paint. Let's go on to that. So we got a couple things going on here. One is notice of the federal law, and Section B talks about renovation, repair, and painting. So if the house has lead paint, the seller can do some of their own work without being a lead certified specialist, as long as it's minimal in scope. So disturb no more than 6 square feet per room. That's not a very big area, you know. No more than 20 square feet exterior. So most people shouldn't do lead remediation on their own, right? Because lead paint is bad and the dust is, gets airborne when you start tearing stuff apart, and that's what's bad for you. Hopefully, most people are not going to do that. More interested in Section C about Maryland law. So you guys remember when Maryland enacted their lead law, well, some of you may remember, that it used to be if you had a rental property, and if it was built before 1950, you were required to register with Maryland Department of the Environment. If it was built between 1950 and 1978, it was optional. Now they've changed the law to say if the property is built before 1978 and it's a rental property, you must register with Maryland Department of the Environment. I can't remember. Do you have to do it every year? Is there
Every 2 years.
every 2 years? Okay, thank you. Yeah, so those of you involved in any property management, houses built before 1978, make sure that you guys have your clients do the registration. Um, 37, limited warranty. Okay, people can buy a warranty if they want to. Flood insurance, not going to spend a lot of time on. If you have a property that's in a flood zone, then you have to buy flood insurance in order to get a mortgage. You don't have to buy flood insurance, but if you're getting a mortgage, lender's going to require it, right? There is a little funkiness in Montgomery County anyway, has its own set of flood maps that is a little different than the FEMA flood maps. So Seema and I had this experience together where people bought a house, they wanted to put an addition on, and as it turns out, it's not in a 100-year floodplain according to FEMA, but according to Montgomery County, it is. So they were not able to put an addition because there was no place to put it that wasn't in the flood zone. And we talked with the guy at the county who's in charge of all this, and we're like, there's 7 storm drains like within 100 feet of this property, literally all around it. It's on a corner lot. And he said, yes, but we assume that if there's a major flood event, every one of those storm drains is going to be clogged, which is probably actually true. So anyway, we don't see this very often. I've been doing this for coming on 40 years now, and that's the first time I've ever seen that.
Well, can we hop up to Dr. 38 real quick?
Yeah.
Just with property insurance, Montgomery County, we've got the jury in the like financing, like buyer has to make application for insurance. Does MR they don't have a requirement for that? And then how does that work if there is some major insurance issue that could prevent the property from getting insurance?
I believe that it's in the MAR the conventional financing addendum that says something about insurance. I could be wrong about that. No, I am wrong about that. I don't see it in there. Let's go back to the loan application. Yeah, interesting. I don't see it in a quick read of any of this that says, like in the GCAR forms, it says they have to apply within 7 days. I don't see a similar provision in the MAR contract.
Okay.
But nonetheless, you know, you do want to apply early. That's what I tell clients is, you know, at the front end, just
Yeah.
because it's more rigorous now. Yeah. Are-
Sellers are required to disclose, insurance claims. What's the rule on that?
That's a good
Yeah,
question.
verify.
There's no particular place that I'm aware of that requests the seller to make that disclosure about claims. I don't think it's in the disclosure disclaimer statement.
It's a form
Is there a form?
or.
But that's an optional form, that's not mandatory.
So it's not mandatory, you don't have to disclose.
That's a great question. I would say that if your sellers had claims, yeah, probably a good idea to disclose. You know, we have to sort of evaluate, is that a material fact? Well, I guess it depends on what, you know, what the claim was for, what happened, what repairs were made. I'm always on the side of over disclose and let the chips fall where they may. So, you know, if I were representing the seller, I would suggest they disclose, but most of the time they're not even going to think to tell you, oh, we had an insurance claim, you know, 3 years ago when the whatever happened. Yeah. So certainly if there's you know, work done, like there was a wet basement, it's not usually going to be an insurance claim, but if there's a wet basement and it's been repaired, then certainly we want to err on the side of disclosing basement used to leak. We put in a French drain system and, you know, waterproof the walls and no problem since, and here's the paperwork. You know, that's the ideal way to go about disclosing that. All right, guarantee fund, it's up to 50,000 now. Used to be 10,000 and then 25,000, so 50 grand. So if the fund pays out on a claim against you, you did something wrong and somebody complains and gets some money out of the guarantee fund, then your license gets suspended until you reimburse the guarantee fund. So it's not a great thing. If you can avoid it, do so. The critical areas, you guys are familiar with this. I think we had talked before on the agent resources discussion we've done some months ago that, you know, there's basically a GIS system, geographic information system for every county, and you can have all sorts of overlays to see if you are or are not in a critical area. So this defines it as, you know, within 1,000 feet of state or private wetlands, the Chesapeake, coastal bays, and all the tidal tributaries. So like I have a house in Annapolis. We're in a critical area. It's really hard to do anything within 100 feet of the water in that area. And same thing with wetlands. If there are wetlands, then you may need, if you're going to do anything, you know, grading, drainage, you know, addition, you may need approval from Maryland Department of the Environment and or the Army Corps of Engineer. I've never had to deal with the Army Corps of Engineers, but that doesn't sound like that's going to be a lot of fun. Criminal activity and sex offenders. So basically, this says, buyer, it's your responsibility to check, right? So you can put in any exclusive, expensive neighborhood and find, you know, if you check the sex offender registry, it's people live all over the place. Where it gets interesting is if you happen to know there's somebody next door. You know, if you're the agent, are you required to disclose that?
No.
No. Anybody want to say yes? Okay, you're all going to pass today. Yeah, so you're not required to disclose that on the theory that people move and it's buyer responsibility to check, right?
Do most people check it, do you think? You know, I'm just curious. You check it?
I tell my people to specifically check it when I'm going over it and give them this.
Okay.
It's scary when you do.
Oh, you heard me?
It's scary when you do check.
Yeah.
That's right. Danger, danger.
Yeah,
Indeed.
there's a lot of green and red.
Yeah, I mean, and this is the challenge because, people do come and go and whatever. So, I think there's no obligation to disclose, but it's also not a reason to cancel if they discover later on. So that's one of those things they should check upfront if they're going to do so. Let's see, Montgomery, Howard, most of the counties we deal with, Frederick, this military installations does not apply. But there are areas in Maryland where they're warned that there may be flight operations or munitions testing. That sounds fun. I mean, I know like in Annapolis, every Sunday morning at 8 a.m., they start firing over at the firing range, in the Naval Academy. Why they chose Sunday morning, I'm not exactly sure, but you just hear when 8 a.m. hits, that's when they start up.
Sister lives in Chestertown and directly across the bay from Aberdeen, and
Ah,
they feel it over there.
okay, yeah. Paragraph 45. You guys love this paragraph. Basically, it's saying, I'll sum it up. Brokers are held harmless from everything. Right? So you love this, buyer. You're on your own for double checking, and this is wonderful. But couple things in here, though. You're not making representations about the water quality or the size of the lot or utilities and all that good stuff. Great. You're not advising them on soil conditions, etc. So basically, this is saying, buyer, do your own research. Paragraph D, I want to talk about for a second. Protection of Homeowners in Foreclosure Act. So if you guys remember 2008, for those of us that were doing real estate at that time, the market crashed and lots of people had equity in their properties, but they couldn't make their payments because they lost their jobs. And so there were all sorts of folks running around out there trying to trick people into giving their houses away with the promise that, oh, you can get it back after you get your credit right again. You can lease it and then I'll sell it back to you after you've gotten your credit right. Equity stripping scams. Well, Protection of Homeowners in Foreclosure Act is a reaction to that. And where it makes a difference for us is if you have a residence in default, which is a property where the mortgage of the seller is more than 60 days in arrears. Right? So that's a residence in default. And what that means is if there is a residence in default, seller has the right to rescind the contract within 5 days after contract acceptance. And the challenge here is you're not necessarily going to know that the seller is in default by more than 60 days on their mortgage. Even if you're the listing agent, you're not necessarily going to know that unless you ask and the seller actually answers and says, yeah, I haven't made a payment in 6 months. So that does come up. The other thing that is really important is if you have a residence in default, don't do a rent back, right? Rent back is a bad idea for a couple of reasons. One, if they haven't been making a mortgage payment for the last 8 or 10 months, what makes you think they're going to get out on time when the rent back is over? Number one. So just structurally a bad idea. And then number two, Protection of Homeowners in Foreclosure Act requires that there's a form called Statement About Tenancy that must be signed by buyer and seller and notarized, and settlement can't occur for at least 5 days if the seller is going to retain possession on a rent back after settlement. All right, so sometimes this comes up like we've been trying to get the payoff. We get the payoff in, nobody said anything about the seller being in arrears, settlements tomorrow, there's a rent back, and I get the payoff and see they've got 8 months worth of interest due. Well, guess what? We can't settle tomorrow. we have to delay. Luckily, nobody's moving tomorrow, so at least there's that, but it does wind up having a last minute problem arise. So if you're going to do a rent back, make sure that there's no residence in default problem would be my counsel.
Be a lawyer to say would be my counsel.
No, I think counsel,
Like, that's like a cool thing to say, yeah.
I think you can use that. I can use that. Yeah. You're not a counsel. Well, you could be a counselor. You might be a camp counselor. Homestead property tax, you guys, everybody's familiar with this. This is important as we're getting to March and April that your clients get on this quickly if they're on the buyer side. So new tax bills come out July 1. So the way the property tax system works is once the property is transferred, usually about 45 days before July 1, like mid-May, SDAT is sending data to the counties so the counties can generate the property tax bills, right? And if your buyer has not yet submitted their homestead tax credit application by that time, then it's going to look to the county like they're not entitled to a homestead discount. So different counties treat this differently. Montgomery County, where I think a lot of us do most of our business, it's a $692 per year discount on your property tax bill. So that is, Montgomery County's homestead is much better than most other counties in some ways, right? So you want to have your buyers go ahead and get that in quickly so that the new tax bill that comes out July 1 reflects that discount. Okay, everybody good with that? In order to get the application approved, they have to first change their official address with motor vehicles to be their new property. So people that are settling, in September, they got a lot of time. But people that are settling in April, they want to do that pretty quickly and get their application in pretty quickly so that the new tax bill gives them the discount. Right? The other thing about property tax notices says if you transfer after January 1, the owner can appeal the value. So we don't see a whole lot of property tax assessed values being higher than the actual value of the property. Anybody have one of those recently? No, because usually like the assessed value was 2 years ago, 3 years ago, depending on where you are in the cycle. So most of the time, the value is higher than what the assessment says. So people aren't going to bother to appeal their assessment. But you could. There are circumstances where, there was a casualty, half the house burned and you're buying the shell to rebuild. All right, appeal your assessment because you shouldn't be paying on full normal value at that point. All right. Section 6, everybody good? Ready to move on?
Yes.
All right, we're rolling. Buyer gets to choose their own title insurance company, title lawyer, settlement company, mortgage lender, or financial institution. So, hey, choose us, right? But no, your buyer gets to choose. So we have this occasional debate where the seller wants to use a certain settlement company and it's written in the contract, settlement will be at ABC Settlement Company. And then buyer looks at this and says, wait a minute, I have the choice. Well, if you guys remember Al Monschauer, some of you do. Yeah, okay. Great guy. He's passed on, unfortunately. So I had this conversation with Al because back when we were doing lots of short sales, this was a big point of contention where sellers wanted to, have a settlement company do all the stuff they needed to get their short sale approval. And, that's where we get paid for all the work we did. And then the buyer would say, well, I'm going to switch to XYZ. So the question is, if you write in the contract, ABC Settlement Company, has the buyer made their selection and must they stick with it? Or do they get to change their mind later on after negotiating that in the contract? What do you guys think?
I think it has to be mutually agreed upon.
Okay, anybody want to say buyer gets to change their mind later?
Yes.
Okay, we have a debate. It's not clear. I'll say that. When talking with Al, whose opinion I respect a lot, he said, no, if that's a negotiated term of the contract, then the buyer has made their selection. So that was his position. I think you could just as easily make an argument the other way. Usually it's not worth fighting over because we're just trying to get a transaction to close and help these clients buy and sell, right? But sometimes it is an issue, especially if like the seller has incurred expenses to the attorney at the settlement company. And now this switch means it's going to cost the seller a lot more money because now they've got to pay me $2,000 for all the work I did to negotiate their short sale instead of me making some money on the settlement, so you can make that argument either way. Deed and title. This one's important and often overlooked, and people's eyes glaze over when they read this paragraph. So I'll give you the Reader's Digest version. In Maryland, we normally do a special warranty deed. And what the seller is promising to deliver is good and merchantable title, free of liens and encumbrances, except. So good is free of doubt. Merchantable is, or marketable title is basically that which a normal buyer would accept without any special conditions, and you can get title insurance on it without any special endorsements or that sort of thing. The except is use and occupancy restrictions, generally applicable to properties in the area. Publicly recorded easements for public utilities and easements which may be observed by inspection of the property. All right, so basically, when it says free of encumbrances, well, every title has some encumbrances on it, just about. Every once in a while, I'll find a farm property that literally has 0 encumbrances, but that's really unusual. Usually we're going to see, BG&E or Pepco easements and, water and sewer easements or anything like that. Anything in a subdivision has lots of encumbrances on it. But those are all acceptable encumbrances. We also have the provision that says buyer expressly assumes the risk that covenants, zoning laws, or other recorded documents may restrict use of property as intended by buyer. So why is that important to us? It's important to us as real estate professionals is if your buyer has always dreamed of parking their RV and their boat in their driveway, and there are covenants that say, like in my neighborhood, no boat, no RV, no chickens, no livestock, no garages more than 2 cars. So we've got all these covenants from the 70s. All right. So those all affect the property, maybe. And that's where the challenge is. We may have have we talked about covenants before?
We did one last year,
Okay.
talked a little bit about it.
Yeah. So what does that mean for us in practice is I'd suggest that as you're talking to buyers, find out, do you guys have any plans for this property? Are you dying to put a swimming pool in? Do you, RV, boat, do you want to raise chickens? All sorts of things to find out what they intend to use the property. Because if they have anything other than, I just want to live there, then we may want to include a contingency so that they can review the covenants or decide, all right, I don't have to have chickens, as the case may be. So this is important to us because where this comes up is after settlement, when the buyer gets the letter that says covenants prevent parking your RV in the driveway, right? So you got to move it, get rid of it. Right, so that's that's a bad scenario.
Can we talk about that a little bit more, just 'cause this comes up, especially out here, where we do have some of these subdivisions that are covenant, but the seller doesn't put it on anywhere on the disclosure disclaimer statement, so the buyer doesn't really know, and someone's agent doesn't know that there is any covenants. Um.
Hmm.
Is the sell, I mean, and then it gets back to, well, shouldn't we have known? Shouldn't the seller disclose it? Shouldn't the title company have found it? Like, what can we do? Like, what do we do as the listing side, and then what do we do as buyer side?
All right, all great questions, and yes, problematic. So one is ask your buyers if you're on the buyer side, any special plans. If there are special plans, let's include a covenant review and let the settlement company know so that they can order title and pull all those covenants and make sure that it's not something that is going to impact them. So that's on the buyer side. On the seller side, this is harder because sellers usually don't even know, in a lot of cases, that there are covenants, right? So I believe on the disclosure disclaimer, there is a question, are there any recorded covenants that restrict use of the property? Am I correct on that? Yeah, okay. So there, we have the opportunity for our seller to make an inadvertent misrepresentation when they check the no box because they don't know, it's never come up for them, whatever. I'll tell you what our policy is because we've been burned by this before as a settlement company. In a couple of cases, one of them was guy bought a property, wanted to make sure he didn't have a homeowners association, found a property without a homeowners association because he was a ham radio guy. And he erected his ham radio tower and then promptly got letters from the neighbors saying you must remove your ham radio tower because it's against the covenants. And somehow that was our fault as the settlement company, even though he had never told us that he wanted to erect his ham radio tower. So anyway, our policy generally is if we have these old covenants that are not part of a homeowners association, we will pull them and email them out to agent and buyer to make sure that they are aware of them. So that's, sort of the horses out of the barn at this point. We're already, 20 days into this deal at this point when the buyer's like, oh, wait a minute, you mean I can't park my RV or build my ham radio tower? This is a problem. But better to be a problem before settlement than after is the way I feel about it.
But is that a back out? Because I've been in that situation when those covenants come out when you're doing title and then you're sending them to me. I appreciate that. But like you said, we're well into it. Can they back out based on what's in the contract if you're using Amar?
It depends. And what I would say on that is if the seller had checked the box on the disclosure statement, yes, we've got covenants and we've got the provision in here that says buyer assumes the risk, then I think the seller's got a pretty good argument to say, well, wait a minute, buyer, that's your own fault. You should have included a contingency if that was important to you. I can also see the other argument that says, my bass boat, I love more dearly than my children, and I'm not going to park it at the U-Haul place down the street. So, I'm going to back out and I'm going to claim, seller, you made a misrepresentation or failed to make a representation you were obligated to make. So I can see this argument going either way. And, we can have a 60-page contract and still have gray areas depending on the circumstances. So not a great answer, but I think that's the reality.
Be a problem with the lender though, too.
We don't see lenders care about this very often. Because there usually aren't any covenants that would, diminish the value of the property. So just because this buyer can't park their RV or whatever, doesn't necessarily mean that a lender would devalue the property.
I think I've had instances where a lender, where I was the listing agent or lender, didn't make us think about it.
Like what kind of,
I think there were like maybe even voluntary dues and nobody paid them.
they shouldn't care about voluntary dues because they're voluntary. Yeah. Yeah, I mean, I don't think I've seen that. And the other thing about these covenants that's really difficult is there's this principle of latches, as my friend John reminded me, that if let's say there are covenants in the neighborhood that people have routinely violated over many years in a variety of different ways. Well, then you move in and park your RV, and the neighbor says, I hate that eyesore, and I'm going to try and enforce these covenants. Well, it's going to be difficult for them to enforce the covenants if the covenants haven't previously been enforced. All right, so there are some neighborhoods that have covenants where the Architectural Control Committee is really serious about their covenants, right? So I did have one a couple of years ago where the covenants required stone or brick retaining walls. My buyer did not know this when he replaced his retaining wall with wood. And this neighborhood was very serious about their covenants, and they wrote him a letter, and they clearly have been enforcing the covenants all along, so he had to change his retaining wall. Luckily, it wasn't that expensive. He just got stone facing, so it wasn't terribly expensive to fix, but nonetheless, it needed fixed. So it just depends on what you've got. So I think I've told you before, like in my neighborhood, no chickens and no garage over 2 cars, and I have both. And if anybody complains, I say, well, they got a 3-car garage, they got a 3-car garage, they got a 3-car garage. These people have chickens, these people have chickens, these people have a horse, for God's sakes. So there's different defenses to that, but generally in a neighborhood that does have covenants, every homeowner in there is vested with the right to enforce the covenants against everybody else, unless you've slept on your rights for so long that everybody relies on the fact that the covenants are no longer in effect. I see this a lot also with builders doing tear downs in Bethesda, where there'll be, covenants from the 50s that call for, no architectural, you can't build anything unless the architectural committee approves of it. All right, well, the 3 guys that were named in the covenants in the 50s that were the developers at that time are no longer around. So what's somebody to do? You just got to take your chances, builder, and, build what you're going to build, and you're taking your chances. And title insurance is not going to cover it because title insurance is going to take exception to those covenants, which essentially means we cover you, you've got good title, buyer, except for any damage from these covenants. So it's basically a buyer taking their chances thing.
But does the NPR listing agreements have a place, Stephen, where they answer this question about governance?
It's in the on that last page that basically says, are you aware of anything? And it's written out in that HOA. It's kind of this big blank that should be included. Back in the day when Al Monshar was around, we actually had called him on that because he was like, that should cover disclosed covenants and undisclosed covenants. So it covers, if you are aware of rules, those need to be listed there.
Yeah, so to the extent your seller knows, and that's the challenge. And if you have one where you think there might be covenants, and you want to check, call me. I can do an internal title search and usually find out. Now, if it's covenants from the 20s, it's going to be really hard for me to find something from the 1920s without having a professional abstractor do it. But usually I can chain things back without too much difficulty. I'm not a professional title searcher. I'm really good at analyzing, but not finding, or anything, I don't know, before like 1976 is indexed differently in the public records, and they're really hard to find.
I thought you had said something about, for my own community, about equitable estoppel, which was that you couldn't really enforce, if nobody, the example you gave, if nobody had, enforced anything, and then somebody does something naughty, which we all do in our community, with sheep, in the backyard. You said it would be hard for somebody to go in and sort of
Yeah, and that's that concept of if you've slept on your rights for years, people come to rely on the fact that you've slept on your rights and therefore you can no longer enforce them. Is that latches or equitable estoppel, John? I think she's right.
I do.
I think she's right. Okay.
I was paying attention in that class.
All right. Anything else you guys want to talk about on deed, title, covenants, HOA? We know if it's an HOA, then different story altogether because there's an architectural control committee and some neighborhoods are really serious about it. Does anybody work in Virginia? And you guys do Virginia?
I do.
So if you sell a house in Reston,
Oh, yeah.
you pretty much are guaranteed when Reston, when they do their HOA inspection before delivering HOA documents, there's going to be a list of things that the seller is required to repair. I've talked to a few agents over there and they said, yes, we know this. It's 100% of the time where they use that as an opportunity to make the seller upgrade the property. We don't see that quite so much in this side, but we do have some neighborhoods that are really serious about their architectural control. Joe, you had asked me about HOA inspection.
Yeah.
So tell me a little bit more about how that comes up when you're ordering the resale package.
Some associations, it's I guess you get an option if you want to do your resale package with an inspection or without an inspection. And some sellers opt without the inspection and just.
Seller gets to pick that?
Well, when you're ordering the docs, yeah, and some associations, I mean, there's a million ways that they slice and dice it. Some it's already included, but some they make it optional.
But you know, the resale certificate at that point, on that section that where it says. Are there any violations? What would that, it just be left blank? So.
Yeah, or it'd be left blank if nobody has complained and the HOA doesn't have any knowledge of it. So I guess if you opt for no inspection, if you're the seller filling this form out and paying for these documents, does that mean they never inspect? Or does that mean they're just not inspecting right now? I don't know how that works.
Who's responsible for the violation? Buyer, the new buyer gets the violation passed on to them? If there is a
Yes.
violation?
It goes on to the
And
buyer.
that's like signing a disclaimer instead of a disclosure.
Yeah.
With-
I thought it was
so, like,
required to
if you
do
have no knowledge of having violated or, violated anything. That,
Yeah, not all communities do inspections anyways, right? And there's some that don't do them, but there could be violations that could be found later on down the road as well.
But wouldn't the seller only be protected if they sold it as is?
They would have, it depends on what that resale, like, so the resale search, like the resale documents, like in MR, the seller can fill that out. Basically say they had no knowledge of any, which they had no knowledge because no one ever knocked on the door and said. Your shutters need to be black, not red.
So how would the buyer do the due diligence in that?
Right? They can't.
They can't.
Buyer what?
How can a buyer do the due diligence? They're not gonna be able to, they can't initiate an inspection for a community that doesn't do it.
Well, the way it works in my community. But it's a condo community, so that's different than an HOA. But if we miss something on an inspection, because we don't give anybody the choice of whether or not there's an inspection. But if we miss something. We cannot pass it on to the new owner. The condo association would have to go to the new owner and say, we made a mistake. And the condo association would have to pay for the correction. Really? Yeah.
But that's not really true, but I see his point where he's like, as a buyer's agent now, when I'm gonna look at a blank. That's the thing I am gonna go back to if I'm representing the buyer is saying. Have you actually done a, has someone looked at your outside? Because right here in Forest Crossing. You're right, it's not required. We provided it because I told them that's what you're supposed to do. I thought it was required to have my sellers do it. So you can request a further one so that it's not left blank. And when I'm the seller's agent, I am making them do it.
Yeah.
But you're right, if it's now left blank on a buyer's, because I just assumed it was required to run practice that way. But if people are pulling it and it's not required, which it is not here, as the buyer's agent, you're making them. If you want to cover your buyer. It's
Yeah.
Well, I didn't
Because in the case
realize
was,
it was an option.
yeah, so in this case, it wasn't required, but then the lender required it.
Oh, good.
But now the community association, which already had a $468 HOA resale package, says, okay, well, we need $498 because it's a whole, like, they only had one option. It was A or B. They didn't have we've already bought this package. Now we'll just do the inspection.
Is that novelized?
What's that?
Is it novelized?
It was condo search.
Yeah.
Yeah.
Yikes.
Yeah.
Yeah, I mean, it's a good thing the legislature closed all these loopholes to tighten this fee structure up, right?
Yeah.
You haven't noticed yet.
Yeah. Yeah, this is an interesting problem. I mean, the question is, do you want to turn over all the stones and see what's underneath of them, or do we just let sleeping dogs lie?
Like sleeping dog.
Oh, and I like to turn over stone.
I'm gonna have to turn over stone.
Part of the problem gets also that the fees get so high on these that the sellers are looking at ways of
Yeah,
like it takes your breath away if you haven't ordered docs in 10 years that you've owned the home and it's.
right. And worse, and you have two associations, you know, we got a master and a sub association. We got to order it twice. So there goes $1,000. It's absurd. All right. Adjustments.
Real quick,
Oh, yeah.
nuance in this 49 with the delay of closing.
Okay.
You run into this a lot and you like.
That's a great question. Yes.
Oh.
So we do occasionally have, where we run into problems is usually things like there's an unreleased trust, meaning seller or a seller's predecessor in title had paid off a loan. And in the bad old days, lenders used to send their borrowers, here's the release, you need to take it to the courthouse and file it. Which borrowers are like, oh, cool, put it in a folder, and then I'm moving, I'm going to throw all these old papers away, right? And now we're left with, we have to somehow chase down, a release because even though we don't think any money is still owed on that mortgage, it is nonetheless a superior lien on title. So we got to chase that down. Sometimes this is easy and sometimes this is really hard. Lenders have gone out of business over the years and so took over some of their loans and somebody else took over others of their loan portfolio. And sometimes, if we've got a settlement statement where it shows paid off and a loan number, hallelujah. Sometimes people keep their tax records, which will have a 1098 in it from their mortgage, whatever the 1098 the lender sends you at the end of the year with how much interest they charged you, that might have a loan number on. So there are some ways to find documents, but it gets to be a real challenge when there's nobody who has records. So yes, this can be an issue where some extra work is required and there could be a delay. We don't often see other things other than that. Unless like the seller's in bankruptcy or something like that. But if they are, they should have disclosed that. That shouldn't be a surprise.
So it's an automatic, the seller gets 14 days to cure this.
Yes, I think that is correct. It says seller shall have the option to cure. And the date for settlement shall be extended for not exceeding 14 days. If I'm able to obtain a cure, then buyer can either accept title such as it is, well, that's not going to work if there's a loan, or terminate the contract and get reimbursed by the seller for the cost of the title search and not to exceed 0.5% of the purchase price. So, yeah, I mean, you could theoretically have a deal fall apart over this. There are other options as well. We've occasionally had a seller have to go buy a bond which is basically you go to a bonding, it's like the bail bondsman, except for real estate. And you buy a bond that somebody then signs a release because they have a bond that you've paid for thousands of dollars, and the amount that the bond costs you depends on the liability that's on that mortgage. So $100,000 loan would be cheaper to get a bond than a $500,000 loan. There's more risk for the person on the other end. So we sometimes see this. I don't know, John, can you think of one where it was like we just couldn't fix the problem? I can't think of one.
I'm actually working on one right now, which the owner of several properties took out a loan, which was secured by these 3 lots, and then re-subdivided those lots. And and there was still a loan, actually the loan's in foreclosure. And we can't get a release because we can't really identify without a surveyor going in and comparing the old plat versus the new plat to see how much of this property that they're attempting to purchase is affected by the old description, because it's not the entire lot. So they've been going back and forth for about 5 months. Finally, there's no release coming because now it's in foreclosure. And so that was a G car, and there's a distinction here. This is 14 days, G car is 30 days. And we're probably 5 months in now. So they're signing a release to get out of it.
How quickly does an issue like that come up? Just that's one of the things, like, when I look at this, do I need to scare my buyers that, like, hey, settlement could be delayed 14 days and we won't find out until the morning of closing? And we know this pretty much.
We know this pretty early on, though, and this, I think, as Mark, it doesn't come up very. It's a kind of unique scenario, how many people had a situation like that. But getting those releases, like what happens if there's an unreleased trust from Countrywide, no longer around, obviously, right? Or sometimes we'll see the original loan that the developer took out for $10 million for the community, including this lot that was never released when that was, sold. And that builder or developer is no longer around, and maybe the lender's no longer around. So we're usually able to overcome things like that.
Yeah.
Isn't there a walk around for that though? Like, don't you have, for the unreleased trust, don't you have?
Sometimes, if there's,
About a month?
this is why people should buy owner's title insurance.
Right.
So if it's a developer loan and they've got a title insurance policy, then we go to whoever issued our current seller's title insurance policy and say, hey, insurer, you insured the seller that they had clear title and this loan was never released. And they issue what's called a letter of indemnity, which says to the next people, you'll be held harmless from this. So if we need to do anything, we'll do something with it.
But in the case of somebody like Countrywide, where they haven't been around for a long time, I thought Maryland has a law that you file a document that if they haven't collected that money for years and years and they, they're not around or whatever, there's something that they can file, and then in 30 days, if there's nothing back, it's like, okay, and then you get the title insurance, but I can't remember what it's called.
Yeah. There's a couple of things. One is mortgages have a 1240 rule. So what I mean by that is the mortgage is automatically extinguished if it's more than 12 years after the maturity date. So if the loan matured in 2000, looking at that deed of trust, and we're now at 2026, we can ignore that even though no release was ever filed.
Right.
All right, so there's 12-year rule or 40 years from the date the mortgage was taken out if we can't determine its maturity date. So that's one thing that just the passage of time will work to erase those old mortgages. I'm not aware of anything of where you get to file something in court other than there's the company that paid off the loan. So like if I pay off M&T Bank and M&T Bank never provides me the release, then I can file in the court. I got to give them notice first. Hey, you haven't provided the release. And we're going to file in a copy of the canceled check proving that the loan was paid off, and it's got to have certain language on it, paid in full and the loan number and whatever. So there is a workaround, but that's only if the settlement company who paid them off has the records.
Sometimes when what we're able to do is just go to the title insurance company, collect all the circumstantial evidence, relating to that. It's 3 owners back, so there's been several closings, what other information we can come across, and then we go back to the underwriter and say, can you give us authority to insure over this? So if it does pop up, you're willing to cover it, so they have to make an educated guess, likelihood of a claim. And so there's no necessarily release file, but you can get a policy, your owner gets an owner's title insurance policy, it says, if there's any claim related to that, I'm covered, so I don't have to worry about it. That can go forward.
But they don't have to, because that's technically not good and marketable title. It's insurable title, but it's not marketable, right? So, a buyer could say, that's nice, but I don't want the owner's title insurance. I'm not paying for that. And if you can't give me marketable title, then seller, you haven't met your obligations and I'm out.
You know who Zenas Morenos was?
Yes, I do.
Okay, well, I sold his house. And there was a $7 million, lien on it. And my people were VA with no money down, and I was like, roll the dice, who's gonna come back to collect it? The house is worth 600,000, so they rolled the dice. And then they made a really tiny profit, like many years later, but yeah,
Yes.
there's no way the bank was ever gonna collect them.
So attorney defalcation does happen. It was a settlement. Zenas Marino was a settlement guy who was very successful, and then he started taking escrow money. Yeah, so that's not good.
We're on the drive, so.
All right, let's talk settlement costs or adjustments and settlement costs. So adjustments, we're going to prorate everything that's periodic charges. That's going to be front foot benefit, condo, HOA, property tax. Easy enough, right? One special note is there's no reimbursement to the seller for oil or propane. So if you have a property where you represent the seller and it's got a buried propane tank, or above ground for that matter, or there is an oil tank that provides heating, then you want to make sure your seller is aware that they're not going to get reimbursed. So occasionally I hear the story where the seller fills the tank right before settlement, so to be easy to adjust the 250 gallons at $4 a gallon. Uh-oh. No, that's not the way the contract is written. So don't let your sellers with heating fuel or cooking fuels be in that position. So just tell them, hey, we got oil heat. Just know you have to have the heating working conditions, so when the buyer does the walkthrough, but you don't have to fill the tank for them, right? You're just not going to get it back. So I have oil heat. Oil heat's expensive. It's $4 and change a gallon right now. So if you have a 500-gallon tank, that's a lot of money, right? Different than our GCAR forms, under the settlement costs provision, paragraph 51, this one says the buyer pays all the settlement costs, basically. So the GCAR form also, which I personally love, because it says seller will pay a reasonable closing fee for services rendered to seller. This doesn't say that. So if you're dealing in, property in Howard County, and you're using an MAR contract here, and the settlement company wants to charge the seller a settlement fee, the listing agent is probably going to say, no, you can't do that, because the contract says this is all a buyer expense. And they're right, and then we waive it. I don't move it over to the buyer side. We just waive that. Bye-bye money. Yeah, so that's, a little bit different than we're used to in Montgomery County. This does have a recent amendment, though, that says sellers advise that if seller can't come to settlement, there may be an additional charge, and they should check with the settlement company for what the additional charges will be. So if we do a remote online notary, there's a third-party platform that you must use and they charge, and we pass that charge on. That's just the way it is. This paragraph was recently amended in this version of the contract. Since the pandemic, having buyers and sellers at the same table together at the same time is not as common as it used to be. Yeah. Transfer taxes. This is also a little bit different than we're used to in the G-Car form. So first off, it says if buyer is not a first-time home buyer, we split taxes unless we fill out the blank otherwise. All right, so that's the same. The last sentence of A is different. Buyer shall be entitled to receive the benefit of any local owner occupancy reduction offered by the jurisdiction where the property is located. All right, so if you're using this contract in a Montgomery County transaction and it's going to be an owner occupant, so we know that there's a reduction in the recordation tax for owner occupant, right? It's an $890 discount right now. So in normal circumstances, that's split between buyer and seller. Each side saves $445 because we're splitting these evenly. However, this sentence says buyer gets the full $890 discount. Now, if you're in Montgomery County, you're probably using the Montgomery County jurisdictional addendum to the contract, which reverses this and says, no, we split it evenly. There are other counties that do have a first-time home buyer or some special owner occupancy discounts. If that's the case, then this paragraph would control where the buyer gets the benefit of that entire reduction. All right, so have I confused you thoroughly? First-time Maryland home buyer. All right, so first thing is, what if they haven't owned a property for more than 3 years? Are they still a first-time Maryland home buyer? No, they are not a first-time Maryland home buyer. Yes. What's that?
You said
Over 3 years. How about over 10 years? How about over 30 years? Now this is, yeah, so this is one time ever.
and they got first time home buyer.
All right, well, they probably shouldn't have.
That's what.
So the loan programs reset, some of them reset at 3 years,
Yes,
but not the tax credit.
yeah. So you were right and they were wrong. Yeah. So the test for the Maryland discount on the test is, have you ever owned property that was your principal residence? So they did it wrong and they had this buyer sign a fraudulent affidavit, right? Because they got a discount they technically were not entitled to.
So if you buy investment property, you're not a first time Maryland home buyer?
This is a great question. No, so you could have 12 investment properties in Maryland and have lived in Virginia your whole life. And then you buy your 13th property in Maryland that's going to be your principal residence. You are a first-time Maryland home buyer. Yeah, so it's not, have you ever owned a house in Maryland before? Have you ever owned a house that was your principal residence? And I also have the question with, well, I had bought a property with my now ex-husband. On this time, I'm buying it on my own. And the test is, well, were you on title to the property? If so, you're not a first-time home buyer. Right? Or my dad added me to title to the property, when he was getting elderly. And then after he died, I lived in the house for a little while, and now we're selling that and we're buying another one. So this is the first time I'm ever buying a house. Well, you're still not a first-time Maryland home buyer. So it does, it seems like it would be a relatively easy analysis, but you have to parse through it because there are a bunch of different circumstances that you got to evaluate. Maryland non-resident seller. Let's talk about that and FERPTA together. So if your seller is, let's say they are a Texas resident and they're selling their Maryland property, all right? So there's two ways to avoid the Maryland withholding tax. Way number one is be a Maryland resident. That's easy enough. Our person moved to Texas a year and a half ago. They're not a Maryland resident right now. Way number two is the property they are selling was their principal residence for at least 2 of the previous 5 years. So the test for sale of principal residence under federal law, principal residence for at least 2 out of the last 5 years. And SDAT still has it listed as principal residence. So this is where, you get punished for doing the right thing sometimes, right? No good deed goes unpunished. That applies here. So let's say your seller moves to Texas a year and a half ago, and they call up the county and say, by the way, please send my tax bills to my new residence in Texas. Well, then SDAT is going to say not a principal residence. And therefore, you're still going to be subject to that Maryland withholding tax because you're not a Maryland resident and you don't satisfy both prongs of the second test. Okay. What is this tax?
A lot of money.
Sometimes it's a lot of money. Here's the important thing to know about it. And, people freak out about it. And I try and talk them off the ledge to say, no, don't jump. It's really not that bad. What we're establishing here is a withholding against the capital gains that you may or may not owe. So it's not actually an extra tax for leaving the state. It's if you have a capital gain in Maryland, then they are collecting a withholding at the time of settlement. So they know you're going to file a Maryland return to account for your gain to Maryland, and you're going to pay something. So the amount that you pay at settlement has absolutely nothing to do with how much you actually owe in capital gains tax. And I'll give you 2 examples to illustrate this point. Let's say you bought this property 50 years ago for $1,000, and now you're selling it for $500,000, and you have no mortgage on the property. All right, so you've got a $499,000 gain. We got a big gain here. If you've got no mortgage on the property, you're going to pay 8.25% of the price at settlement. You're going to give that to the settlement company. It's going to take it from you on the settlement statement. We're going to give it to the clerk of the court when we record the deed. And then there's also a return that goes with it. And that return is going to go to the comptroller of Maryland. And then when you get around to doing your income taxes for the taxable year in which you sold the property, you're going to file a schedule, a Maryland return that'll show, oh, well, I had all these capital improvements that I made, and this, that, and the other expenses of sale and expenses of acquisition. So I don't really have a $499,000 gain. My gain really is only $200,000, in which case you're going to get a big refund because you had 8.25% of $499,000 held. You only owe capital gains tax on $200,000. Therefore, you're going to get a big refund. All right. So it's just like withholding from employment. I'm talking to a bunch of independent contractors, so that doesn't really apply to you guys, but unless you have other jobs. So it's not really a disaster, and there's a way to avoid it. In certain circumstances, you can get a reduced or eliminated withholding. So we could also have the circumstance where you bought this property a few years ago for $1 million, and you're selling it for $1 million. If you've got no mortgage on the property and you don't apply for a reduced withholding, they're going to take $82,500 at the time of the settlement, subject to expenses of sale. Make our math easy and not use that. Whereas if you apply to the state to say, no, state, I want a reduced withholding because I paid $1 million for this property, I'm selling it for $1 million, my gain is actually $0. Even though I'm going to walk away at settlement with $1 million because I've got no mortgage on the property. So the important thing to know, Orla and I just went through this, you have to apply at least 21 days in advance.
You got it, 100% by the hair of Virginia. We call Jason Radcliffe.
Yeah. So there's one guy at the state comptroller's office that deals with these applications for reduced withholding. And that's why they're very serious about their 21 days. But if you're really nice to him, then maybe you can get it in 20 days or 19.
19. He actually called me and he said, I am pulling it from the stack. And then he said, I remember your name and is anybody staying in Meriden? And I'm like, nope. Like, you gotta do something about the taxes, so
Yeah.
we'll see. He's a nice guy.
Yes, he is. And he's working hard. So at any rate, if you've got one of those circumstances, look on the SDAT records. I recommend not relying on the Bright MLS data, but go actually to the State Department of Assessments and Taxation website to make sure how it's coded, because I'm not sure how often that data is updated in Bright. So go to the source to see whether we're going to be able to meet the tests, or you can always call one of us. Yes, John.
Unfortunately, that rate has increased as of January 1st from 8.25% to 8.75%.
8 3/4. I'm living in the past.
Wow.
Individuals.
It's cheap back then.
How?
Yeah. What is it now for
That
corporation?
didn't change.
And that's 8 1/4
Now is, I think,
or 8 1/2?
8.5,
Okay.
When did that go up, did you say? I'm sorry.
January 1st.
Oh, my word, okay. I'm still in the Stone Age.
Well, that wasn't that long ago. All right, FERPTA. This one is a big deal. If your seller is not a US citizen and not a permanent resident. Right? Permanent resident is generally defined as having a green card, right? So work authorization. If they're not either of those, then generally the transaction is going to be subject to a FERPTA withholding tax. This is a big deal for two reasons. Number one is if the withholding is not done, then the buyer is liable for the tax that should have been withheld and wasn't. All right. Your buyers have no idea about this. That's number one. And number two, the real estate agent is also liable up to the amount of the commission you earned on the deal.
In perpetuity, or just, is
And
there a statute of limitations on this?
that's a great question. I don't know the answer to that. You know, I guess it depends on whether it's an inadvertent or fraud. Fraud is like virtually forever. Inadvertent generally is 3 years, but I don't know, it could be 7 in tax law. I don't know. I'm not an expert on it. So longer than you want to be liable for it. How's that?
What if they don't pay taxes because they're World Bank or?
Yes, so there is a process for applying for a reduced or zero withholding as well. The IRS is so slow, I don't know that that's really going to work in the time frame of a real estate transaction.
They have to withhold it.
Yeah, and they'll get it back, you know, eventually when they file a return saying they're not subject to it. So we do have, you know, World Bank employees, for instance, IMF, that sort of thing. Diplomats, yes, where they are going to be subject to the withholding unless they get an exemption in advance. The rate is 10% of the price if it's between $300,000 and $1 million, and it's 15% if it's over $1 million. Right. If it's under 300,000 and the buyer is going to use the property as their principal residence, then it's 0. If it's under 300,000 and the buyer is going to use it as an investment property, then it's the 10%. So 10% of the price, by the way, not of net proceeds. Fun, right? There's one other test other than the green card test, which is called the substantial presence test. So depending on what visa classification they are here on, you could get out of doing it if you have been substantially present in the US for at least 183 days of the previous 3 years, counting 1/3 of the days this year and all of the days this year and 1/3 of the days the previous year and 1/6 of the days the year before, or whatever. It's a complicated formula and it depends on your visa classification.
Can I just ask you on this one, because I'm starting to see this a lot, for somebody I'm working with, how long does it actually take? Because we're working with 2 right now. It's been a good 3 months. Like, we have no, they filed ahead to see, you know, to make sure that there was gonna be an exemption for them, and we've heard nothing. So like, how long, do you have any idea, like, length of time?
This is a real challenge. So the IRS has been gutted, and lots of people pushed out who knew these odd programs. And so like there is the office that deals with FERPTA is the business unit in Ogden, Utah. So sometimes you have to know to call the business unit in Ogden, Utah. And the challenge is sometimes the people in the business unit in Ogden, Utah do not know that they are the office responsible for this.
Oh, that's cool.
So you just got to say, okay, and they say, oh, we're going to send you, no, this is a personal tax return. We're going to send you the personal division. Hold, please, click. I'm like, all right, we'll just call back and hopefully you get somebody else who does know that they deal with this. Anyway, Seema, I got no good answer for you. I had one where there was a mistake on the withholding, the money that was sent in, and it took about a year and a half and probably 20 hours of my time to finally get it corrected because nobody knows this program. So I got no good answer for you. It's going to be a while,
Right.
if ever. All right, this is good. I mean, we're going a little slower than I had hoped we were going to get to some addenda this time. I don't know that we are, but we okay? It's 12:15. You want to stop? You want to keep going?
Keep going. Oh, no, I'm just kidding.
We are having so much fun.
Yes, right.
How much more do we have? We got 2 more pages. We get to the end of this section and then we'll pick up section 7 and then pick up addenda on the next one.
Great. All right. So we talked about FERPTA, IRS filing. Okay, seller's got to provide a social security number so we can file a 1099 if they are required. The transaction requires us to file a 1099. Broker's fee, we like this paragraph in this room, paragraph 57. The parties irrevocably instruct the settlement officer to collect the compensation and disperse according to what's in the listing agreement or agency representation. All right, so bottom line is your seller can't say, you know what, I'll take care of Remax later. You know, don't worry about it, settlement company, I'll pay them later. No, we've been instructed to go ahead and pay right now. Paragraph 58, we love also, brokers aren't liable for anything. And then paragraph 59, talking about title insurance. Yeah, but brokers and agents, it includes all of you. The title insurance, so there are 2 different policies that are out there right now. So, well, actually, there's limited title insurance on loan policies, but I won't get into that. So for your buyers, they can either get the standard policy or the enhanced policy. The enhanced policy is enhanced with more coverage and a higher price tag. Most of the time, if you have regular buyers and sellers, not an LLC or a corporation or something like that buying a residential property, then especially in this day and age, we want to go with the enhanced policy. And the chief difference, there's a bunch of minor differences, but the chief difference that I think is of great value is post-policy fraud and forgery coverage. And what I mean by that is your buyer buys a property and then 6 months later, a year later, 2 years later, somebody goes and puts a mortgage against their property by impersonating them. This happens. And then they discover this when they get a credit report, update, or they go to get a loan or go to sell the property and they say, wait a minute, I never did that. So the basic policy does not cover this because it happened after the date of policy. The enhanced policy will cover that fraud, forgery, etc. If the fraud or forgery was prior to, either policy is going to cover it. So if there was fraud or forgery seller or the seller's predecessor in title, that would be covered under either policy. So the main difference is post-policy fraud and forgery. And AI is making forgery and fraud really easy. These guys are so amazingly clever, it's unbelievable. I have a relative who apparently bought a property in New Hampshire unbeknownst to him. And his question was, I didn't think my credit was good enough to buy a property. Anyway, yes.
Is it possible, I called you on this, but and I do have the answer, but is it possible if we're getting a phone call, they bought a regular policy, a non-enhanced policy, it's been a few years. And now they want to go to an enhanced policy because it's being carried on the news everywhere and, there's a lot of information going out on this all of a sudden. Do they have the opportunity to come back to you and say, hey, I'd like to now, I own this home, I've owned it for 3 years, can we go ahead and upgrade our policy?
What did I tell you? Because I don't remember.
What?
That's a great question.
Yeah.
What you said, and actually did work, thank you, Mark, was, that you could not add them onto the policy, but to send them back to who they got the policy from originally.
Okay,
And their policy was enhanced for
for the additional premium.
Yes, because it was one of the few I did not settle with you, so, very few, but, they did go back and the policy was taken from a regular policy to an enhanced policy. They simply just paid more.
Yeah. And the only other thing to know about that is the enhanced policy is only available for residential property purchased by a natural person or a revocable trust. So if you've got people buying, a farm in the name of an LLC, they're not going to be able to get the enhanced policy. All right, so I think it's different title insurers have different rules, but generally it's like gotta be less than 25 acres. So anyway, not it's for residential property.
Can you get the issue rates on, and will that be enhanced too, if, depending on what type of they had previously?
Yeah, so reissue rate, this is a great question. So encourage you guys to inquire above the sellers. If they have an owner's title policy, then that will save the buyer money, whether the buyer is getting an enhanced policy or a basic policy, it doesn't matter. There's a discount to be had generally if the seller has a policy that the settlement company can, be delivered a copy of that policy.
It
So,
doesn't matter if the seller has.
no,
It's still good.
yeah, they'll still get it. They can still get an enhanced policy at a discount, even if the seller's policy is a basic one. Different insurers have different rules for reissue rates. Some have a 10-year rule. Some have a soft 10-year rule, depending on how aggressively your settlement company asks them. So it just depends. But generally, if your seller has a policy or can provide evidence of a policy, such as the settlement statement that shows they paid for owner's title insurance, then that'll work. All right. Stop there.
Yeah, that's great.
Guys, thank you all very much. Appreciate it. Good crowd today. And for those of you that haven't given us a try for settlement, we'd love it if you would. Hopefully you're finding value in this, and we are as well. So appreciate it. All right. Thanks, everybody.
Before you know, first, Brianna, Springer's here with children there from that one. Children's medical.
How are you all?
Right.
I'll come up here so not everybody has to twist around.
Thank you.
All right. So I know I know a few of you, I don't know if all of you are miracle agents. So if just for my visual, if you could raise your hand if you are currently a miracle agent and you currently donate back to Children's Miracle Network. Okay. Love it. Love it. Wonderful. So first of all, thank you all for who currently donate. But I do want to provide a little bit more information about it. So Children's Miracle Network is our national program. We as Children's National Hospital are a a member hospital of Children's Miracle Network. And what that means is we're able to work with partners like REMAX and the agents to give back. All of your money stays local. So any money that you decide to donate back to Children's Miracle Network goes to Children's National Hospital right in DC. So it helps our kids right here in the local area, which I find is a really big selling point, that it is a national organization, but all of the money does stay local. So what does your money help? What do your donations make a difference? It all goes to the Fund for Every Child, which is our large kind of unspecified fund, but that helps for art therapy, pet therapy, music therapy, anything that insurance doesn't cover, whether that's upgrading certain things, maybe that's diving into more research or having a new item in the hospital be provided, or upgrading anything to make sure that we are at the top of our game and can provide the world-class care that our kids deserve. So something that not everybody realizes how important art therapy and music therapy is. Some of these kids don't get to leave the hospital for several days, several weeks, some months, and some unfortunately never do get to go home. The art therapy and musical therapy programs, they truly do make a difference. They come to their bedside, they're able to help them kind of escape or maybe understand the care that they're going through a little bit better. They have these teddy bears that they describe different medical procedures that are happening to them so that they understand on the teddy bear what is happening, so that they understand what the doctor will be then doing to help them. So it's really bringing the care down to their level. And I know as an adult, I sometimes wish my caregiver could explain things a little bit more as a layperson. So that is a really specialized care that your funds support. One of the research miracles that we had come out recently is we had a young boy be cured of sickle cell, and that came from our research program, and that truly is remarkable. We have a prom every year for kids that can't go to their own prom, and he lit up the dance floor. When he was first coming into the hospital, he was in so much pain that he didn't know like how he was going to manage it. And we were managing it kind of day by day, but because of the cure, he was able to kind of dance the night away at prom. And that is another kind of event that the donations support, is the prom every year. So how do you get involved? If you would like to become a miracle agent, you can talk to Heather. Sorry, Heather, not to put you on the spot, but you can talk to Heather about signing up. What that means is on every closing, you can designate a certain amount of money to then be donated back to the Children's Miracle Network Foundation. Sometimes people do $30, sometimes people do more. It completely depends, up to you. We encourage all agents to hit that $500 level a year at least, so that you're considered a bronze miracle agent. The levels go up from there the whole way up to platinum. All right. And then lastly, I want to kind of give an introduction to our 2026 Children's National CMN champion, Zoe. Zoe is a young girl who loves art. She was an artist through and through. And at 6 years old, she was diagnosed with cancer. This became her outlet. She was able to do it in her hospital bed. She was able to do it during treatment. This was her escape from her treatment. When COVID happened, she was no longer able to necessarily be in the hospital and have those interactions with others that she was so used to having. The telemedicine became very imperative to keeping her care what it was. And she's now healthy, she's thriving, she's still doing art. So you'll probably see some of the art that I send around this year will be done by Zoe, a truly remarkable young girl, very spunky, very sassy, but truly does love art. And that's another way, like the art therapy can really make a difference in a child's care. On behalf of Zoe, the other 260,000 families we help every year, we truly thank you. We thank you for dedicating the time, giving back. You don't have to do this. This isn't your full-time job, but it truly does make a difference. And I can't stress enough how important it is that our money does stay local. It stays right here in the DMV area and makes a difference for all of our kids. And unfortunately, a lot of families don't ever expect themselves to end up at Children's National Hospital, but some do, whether it's for an asthma attack or a broken bone or something more severe. All of the support of our partners truly make a difference. So thank you all so much. I can answer any questions if anybody has any, but yes.
I would like to say we're a proud sponsor of the
Thank you.
hospital. My son Jason has been in there multiple times, with over like 15 surgeries.
Oh, wow.
And I gotta say, every year we donate money and toy. Around Christmas time,
Mhm.
I got to witness that when you're in a hospital during that time, the kids like December, the whole month of December, they put on this toy drive where the kids can go to, I guess the library is where you host it. And they get to pick toys and kids are so happy. Like you guys do a lot for the kids
you.
there.
Thank you. Thank you for sharing that. And to talk a little bit about what she's talking about is we have a little like Santa's workshop
Yes.
set up. And if the kids want to come down to help select or the families can come down, the patient receives gifts, but if they have siblings as well, they receive gifts. And then we have a wrapping station that they wrap all the gifts for them. So it is a surprise for them. Whether it's for the holidays or we continue to have toy drives and things like that for birthdays and other celebrations as well throughout the year.
So I don't know if, oh, sorry.
Is there anything else that we can do besides financial donations?
So yeah, we can absolutely talk. I have a meeting with Joe and Heather after this, so we can talk about like we could do book drives. So new books is something we could definitely use. We have a library there, a community center that kids take home the books with them. Whether they're a inpatient or an outpatient, we can't keep the books due to germs and things like that, but that is something we can use. We can do sanitary or sorry, not sanitary kits, but like a hospitality kit with like travel size like shampoo, conditioner, toothbrushes, toothpaste, things like that that we can give to the parents that may have an unexpected stay. So we could do something like that. A toy drive we can talk about doing. Those are all ways. So drives of any kind to give back is definitely very helpful.
We also did the blood drive, that's.
Yes. Yes.
I don't know if you guys still do this, but when I was there one year, they offer a masseuse. They give the parents massage. So
Oh,
we did that one year. We got a masseuse and just in the HKU unit.
okay.
Yeah.
I mean, if that is something we're interested in doing, I can definitely.
Yeah, like they.
I would say the sky is the limit. So if we have creativity and there are things that you would love to make happen, talk to me about it and we can see what we can do to bring it to life at the hospital. Anything?
I've also researched, I've benefited from children, so that's why I'm so passionate. My daughter's been a patient there. She's 25 and she's still a patient. So because of the certain clinic she's in, but there had been times where we all of a sudden were inpatient when I thought we were just going down for an ER visit.
Yeah.
And I was still in work clothes and they provided sweats and, everything that I needed to be comfortable for a few days because I didn't have a way to get anybody to me to get clothes and stuff. And also she was in clinic one day during her birthday and they took her to the toy closet and she got to pick a gift for her birthday, which, instead of getting poked and needled all day, she actually got a gift too. So, so it's not just Christmas that the toys are needed.
Absolutely.
Well, thank you all. Thank you so much.
Thanks, Brown.
Thank you.
Songs that go on bigger, like on America.
You have lunch too, right?
I think so. I don't know. That's
It's lunch in the kitchen, please help yourselves.
That I'm good.
Alright.
Mark will be trying up next year. Actually, right.
How old the baby?
Next paycheck comes in, you put it in the spreadsheet, it's like $5. Yeah. They give up.
He's 11, but.
Honor card, you can make this. Honor I'll hire somebody to minimum.
Yeah.
Yeah.